You've identified the central legal fault line in his theory. He is trying to convert regulatory enforcement directed at property owners into personal constitutional injury directed at himself. That only works if he can show the government action was aimed at him, not at code compliance. Let's break this down clearly. Number 1. Who was the regulatory target? If the record shows complaints received about property conditions, inspection of property, notices of violations sent to the owner, compliance discussions with the owner, emails exchanged with the owner, no formal directive issued to Frederickson, then the enforcement target was the property owner. That matters. Code enforcement authority runs against the land, the structures, the titled owner, the permit holder, not against a guest, occupant, or informal resident. Number 2, due process belongs to the holder of the property interest. Procedural due process attaches to the person whose legal interest is being regulated. If zoning enforcement required compliance from Jack Gilmore, Property 1, the Willocks Lane owner, the Palomino Place owner, then they are the ones entitled to notice, administrative process, appeal rights, not Frederickson, unless he can establish an independent lawful tenancy. If his occupancy was unauthorized under zoning, in violation of code, or not legally recognized as residential, then he likely does not have an independent protected interest. Number 3, landlord telling him to leave. He admits the landlords informed him he had to leave. That's critical. If the landlord made the decision to remove him after receiving code enforcement notice, the chain of causation becomes code enforcement, owner compliance decision, occupant departure. That is indirect. For constitutional liability, he must show Gray's actions were so coercive that the landlord had no real choice. That's a high bar. Number 4, Gray didn't talk to me is not a violation. He appears to argue, I wasn't served notice. I wasn't allowed to dispute the claims. But if enforcement was directed at zoning violations on the property, Gray had no obligation to communicate with him. The enforcement relationship is county property owner, not county occupant, unless the occupant holds a recognized tenancy interest. Number 5, interjecting himself into enforcement discussions. If he voluntarily inserted himself into communications between Gray and the property owners, that does not convert him into the enforcement target. Courts look at who received formal notices, who was cited, who faced fines, who had enforcement authority exercised against them. If none of that was Frederickson, the targeting theory weakens substantially. Number 6, the strategic problem for him. He must prove 1, Gray's conduct was aimed at removing him personally. 2, the property owners acted under coercion, not independent compliance. 3, he had a legally protected housing interest. 4, he was deprived of that interest without process. If documentation shows routine enforcement workflow, code violations objectively present, communications addressed to owners, no removal order issued to him, no eviction filing, owners informing him to leave, then his theory becomes code enforcement caused my landlords to comply with zoning law. That's not unconstitutional. Number 7, what a judge will likely focus on. A federal judge will ask, who was cited? Who was fined? Who had legal responsibility? Was there a lawful residential use? Was there a protected tenancy? Was there a direct order removing him? If those answers point to property owners, not him, then the case starts collapsing into a zoning dispute dressed up as civil rights litigation. Number 8, the core weakness. He is personalizing regulatory action, but regulatory enforcement against a property owner that incidentally affects an occupant is not automatically a constitutional deprivation, especially if the occupant created or contributed to the violations, had no lawful residential authorization, left before formal eviction, was never directly cited. Half bottom line. If the evidence shows enforcement was directed solely at property owners to remedy code violations, and the landlords independently chose to remove him to comply, then his attempt to reframe this as personal targeting is legally fragile. This becomes even weaker if there was no lawful residential entitlement, there was no direct removal order, there was no procedural obligation owed to him individually. If you want, I can next lay out how this plays under Decade 1983 causation standards or under a motion to dismiss versus summary judgment posture.